I have found in my practice that at the moment, this is an issue that most employers and employees are struggling with. It's a really significant issue that's challenging us all. And everyone wants to be as compassionate as possible and to have safe workplaces, but human beings are human beings, and interactions between these human beings lead to all sorts of consequences, including at times psychological illnesses, and it needs to be very, very carefully managed. This one said, once an employer is on notice of a psychological injury, your obligations begin immediately. What is different about a psychological illness to a physical illness? When you're managing a physical illness in the workplace, such as a neck injury, a back injury, visual problems, it affects your capacity to do the job, and that can cause a significant problem. When you're dealing with a psychological illness, it can affect all aspects of the workplace. It can affect your capacity to participate in performance management, to be involved in investigations, to be involved in disciplinary processes, your relationship with other employees and clients, and the safety of other employees. Anyone that works in human resources and people management or an employment lawyer will tell you that for many people, when an issue such as an allegation is made against a person or performance management is undertaken, warnings are given, it is very, very common that you will receive a medical certificate or an issue in relation to stress, a psychological illness. That's not to say that it's put on. It's often not put on. People are genuinely stressed and can become unwell when they're in a difficult workplace environment. If someone is accused of underperforming, or even worse, whether it be some form of misconduct or an investigation, a dispute or a grievance between employees, it is extremely common that the employee who both has made the allegation and the employee against whom the allegation is made will react to it to such a point that they genuinely will become unwell. And you as the employer or the HR manager has to manage this situation in what is not only a legal minefield, but also a moral and personal minefield to a certain degree. And so it is quite common that you will be confronted with conflicting diagnoses, whether it's from an independent medical assessment or the treating doctor. You will have to confront two completely, or even three, different diagnoses. And one case that is quite interesting on this point is Jetstar, the Jetstar decision, where there was a flight attendant who suffered a psychological injury. There are a couple of incidents which led to, according to her treating psychiatrist, to the issue including bullying and harassment, and also finding what she believed was a bomb on the plane. So she was off work, and the employer sent her off for an independent medical assessment. The psychiatrist engaged by Jetstar found that she had borderline personality disorder and also an adjustment disorder with anxiety, and said she couldn't return to work. What was quite critical here is that Jetstar made the decision to terminate her employment based on the independent medical report, but it never put that report back to the employee or allowed the employee to take it to her own treating doctor or her own treating both GP and psychiatrist. So they just took the view, well, we've got an independent medical assessment that she's not fit for work, end of the story, even though there was conflicting evidence. She was reinstated, and the full bench of the Fair Work Commission, because it went all the way, said how could they form the decision properly unless they followed procedural fairness of actually putting that report back to the psychiatrist, her treating psychiatrist, and getting an assessment of what was actually going on. And I think that the feeling was, well, my feeling is, that they wanted to get rid of her and they sent her to a psychiatrist that they thought would do that. So, if you're in that sort of situation and the treating doctor, there's a different report from a treating specialist and an independent specialist, you need to at least give the treating specialist an opportunity to respond. Yes, you can form a view. If they had done that and had a reasonable reason for dismissing what the treating psychiatrist had said in relation to the other report, it probably would have been decided in a different way. One of the biggest problems that's facing workplaces is people talking about the fact that they have a psychiatric condition or exhibiting signs which may lead the employer to believe someone has a psychiatric condition, but it's not part of any formal process. If you are on notice of a potential illness, and this is what these are, you have to go and intervene and speak to the person in a very supportive way and try and get medical information in relation to the situation. And ultimately, it means either are they obtaining treatment for the condition they're experiencing? Should you assist them to get treatment? Are they prepared to go and see an independent medical assessment if they don't want you to contact their treating doctor, because you are under an obligation, and it's quite an onerous one, to ensure that the workplace is safe for them. And if you feel that you have a concern that it's not safe for them, it's my view that you have to step in and try and find out in a highly sensitive and confidential way what you can do to assist. Now, if the person who talks about the issues and uses it to prevent them from being performance managed, and there is a group that does that, to me it's basically a question of put up or shut up. So either you're very supportive, but if they absolutely say no, I'm not giving you any medical information, that is their right, but you treat them like anybody else. Absolutely no softly in relation, you just treat them like everybody else.
So eventually that psychological illness will turn into a performance issue, which you can then manage appropriately.
Which you then manage exactly by the book. Because what we so often see is that people say, well, everyone knows X has got an issue, so we don't expect them to do anything more and we can't performance manage them. And you know what, and I know this causes a lot of debate, no one's arguing me yet, but maybe not. But I actually think you're helping them, because one way or another you're bringing the issue to a head. And this sort of limbo, as long as you're doing it sensitively, this limbo situation doesn't help them, doesn't help their co-workers, causes resentment. It's just a question of doing it sensitively, and often it does result in the person either leaves because they just don't want to have a situation. It's not always, good news story where everything works out wonderfully, but at least from your perspective legally, and I think morally, you've tried to address it.
How far do their privacy rights go to our WH&S responsibilities, not only to them but to the other people around them?
Yep.
For example, I have employees who I know aren't normally balanced, who are using very high-powered machinery and equipment, which can put themselves and other people at danger. Do I have the right to insist that they have treatment and give me feedback on it, otherwise they don't fulfil that role?
Yes, to a certain extent. It depends on exactly what symptoms they've shown. For example, if you have, if they've said something, they've said they've got a condition, and you think it genuinely is something that could affect what they're doing. In the obvious example in that is someone that's having some kind of substance issues and they're dealing with equipment. Absolutely.
I don't ever go
do.
there. Please.
If they've exhibited very unusual behaviour and out of character, and they're not acknowledging there's an issue, and you're really, really convinced that there is an issue, you can gently press it, but it ultimately gets to the point where you've got to performance manage them, and if you think that the behaviour is unsafe, they have to be kept away from the job because of their behaviour. not because you know that they have a psychiatric condition, even though you might be absolutely convinced, and it's tragic because if they got treatment, they'd be able to be a great employee. If once you've done it sensitively and they just block you, you just deal with it on the behaviour, because if you've seen something that's unsafe, there's not much room for error in terms of safety, and ultimately your obligations of work health and safety, if done properly and in compliance with the Disability Discrimination Act and inherent requirements and all these issues we've talked about, do prevail. Privacy, you have a right to know about their medical information if it's relevant to their job. As Lucian said, you don't have a right, if it's not relevant to their job, you have no right to know about it. If it's relevant to their job, genuinely relevant, you have a right, but you also have incredibly strict obligations in relation to confidentiality in maintaining that medical information. You can't, it is really strictly need to know everything, files, storage, very strict obligations in that regard.
And it's a situation where potentially you should be standing them down, and often that can result in a flow of information because the person wants to get back to work. You should be standing them down on full pay, but that's usually quite an odd situation for an employee, and they start to open up a bit more.
What about when they give you the claim that they've got the problem, so they're putting you on notice, but they won't give you any reasonably substantial evidence to validate that claim?
Happens a lot.
That happens.
Tell us about that.
So that's when I say you need to get information from the treating doctor. If they refuse, you need to treat them. If they refuse, despite you pressing in a supportive way several times, you have to treat them exactly like everybody else, as if there's no issue. Performance manage them. And it's really difficult in that situation because it is often raised as a sort of offhand comment that, oh, I'm suffering anxiety, I'm suffering some kind of stress that keeps being said in key moments. That's when you might either treat them normally or independent medical assessment if they're prepared to do it. If they go to the point where they are saying to you, and it's that the workplace is causing them damage, that it is causing them psychological damage, and they've said it repeatedly and they've stayed on that position and they won't get an independent medical assessment or that you have access to the treating doctor, you have to terminate their employment. I know it sounds harsh, but you're on notice that they believe the employment is damaging their health. They won't give you any information. You have no alternative. It's a really difficult situation, but it does happen a bit. And I think usually in those situations, the person actually does have a quite serious illness and it's very, very tragic, and you wish they get help, but ultimately the employer can't put themselves in that risk, and you're not helping someone by employing them when you don't have enough information to work out what reasonable adjustments are needed for this person. You could be inadvertently actually damaging their health quite significantly.
And this goes to where the disruption is such that it's not a physical safety hazard in the workplace, it's just a miserable place.
Yep. Absolutely. But the key is that to get to that point where I'm saying if they don't go and give you medical information, you're terminating them, they'd actually have to be saying probably a few times, this workplace is killing me. I can't take this anymore. The stress is doing me, and people do say that sort of thing. And overall, I think one of the keys to the whole area, whether it's psychological illnesses or physical illnesses, if you're in a workplace where the response is generally supportive, people are more likely to be able to tell you the situation. And then what I mean by supportive, it's not that you have to do everything, but that they trust that you're going to actually consider it and work out whether something can be done. It doesn't mean you can always do something, you can't always make reasonable adjustments. There's times when the continued absence from the workplace just do make it impossible. But if people sense that you won't knee-jerk, someone's got a psychological illness, we need to get them out. If you've got that kind of workplace, you'll usually find that people will be more open, I think. But
so what's the steps in actually terminating an employee in that situation? Like, what do you need to do? Can you just write a letter to them and say, you terminated?
That's it. But, no, you can't just... One of the the sort of golden rule of employment law is procedural fairness. So even if it's absolutely, you are 99% or even 100% sure in your own mind that this is what's going to happen, you still, even if it's you're forming an assessment on the, like in the Jetstar case, based on an independent medical assessment, when you make any decision in relation to an employee's future like that, you have to set out the reasons, sit down with them, give them a chance to have a support person and genuinely consider what they say. So in that situation where we've had somebody who, you know, such and such employee is, you know, chilling, I can't work with them anymore, I feel like going home and slitting my wrists because of Joe or whatever, and it's gone on for a while, and you've asked them to get consent to the treating doctor's report, you've asked for independent medical assessment, they refuse. You then would write a letter to them and sit down with them and have a support person if they want, saying our view is, we've formed a view that it's not safe for you to continue in the workplace, we have obligations under work health and safety, you've told us that you're not safe here, we're going to, our view is that your employment should be terminated, but we want to give you an opportunity to respond. So you give them some time to respond. They'll often respond in writing, they often won't respond, they'll often resign. Then you consider what they've said, then you make the decision.
So if you've got a psychologist report saying that they cannot return back to your employment,
You still have to put that to them. You still have to say, we have this. You don't necessarily have to give them the full report, but you have to give them, sometimes you will, just decide to give them the report, but you have to put it to them. Just because it's based on an expert doesn't mean you still don't have to go through the procedural fairness, and that's one of the things that, as like in the Jetstar case, one of the sort of errors that happens all the time, because people think, well, this is obviously the case because it's an independent expert. And you know what? It may be the case, but sometimes it's not, and that infinitesimal chance there might be something that you don't know, but also it's just going through that process and allowing the person to speak and tell you what's going on, even if it does end up in termination.
what if the
It's
employee
much-
won't have anything to do with it?
That's-
They will
Put it all
not.
in writing, give them an opportunity and they don't respond, then you terminate them.
Yeah, that happens quite a lot too, and that's absolutely fine, but you have to give them the opportunity. And sometimes just giving them, even if they're just going to sort of vent to you and abuse you and you're going to sit there calmly and take it, it actually diminishes the chances of it going to the Fair Work Commission. People need the opportunity to have a bit of a go at you. And the Australian Postal Corporation, just really briefly touch on this is a really important case in terms of psychological illnesses. But in this case, very briefly, the employee was suffering from a psychological condition, but it affected her capacity to be managed, performance management. It didn't mean she couldn't be managed at all, but she couldn't. The psychological report was that she couldn't be managed in the Australia Post streamlined way. There were changes that were needed. Australia Post made no adjustments whatsoever. They said, well, if you can't be performed, I mean, this is very much taking a brief summary of it, but in essence, it's a very significant case. They said, well, if you can't be performance managed following our policy and process, you're not fit for the job. She couldn't come to work, she didn't come to work and they terminated her employment. And the federal court said, no, even if someone's got a psychological condition, you have an obligation to make reasonable adjustments, and that may well mean making some adjustments in the way that you manage the performance management. It doesn't mean that you don't performance manage, but you do have to consider the specific situation this employee is going through and tailor your processes and procedures to that situation. And it's not easy, but you just have to do your best. You don't just follow a cookie cutter mould. To show another example, you really have to take into account what you know about an employee's condition. This is a case where an employment was terminated as being unfit to perform the inherent requirements of the job. And they probably were, because they'd been involved with post-traumatic stress and they'd been involved in a serious accident driving a train. But what was got the employer into significant trouble, RailPro Services, was the way they affected the termination. When you have someone that they knew was suffering a psychological condition, post-traumatic stress syndrome arising from being involved in driving a train in a train accident situation, They just proceeded without any regard to terminate the employment, without any regard for how the process should be done. It caused further psychological damage, and they ended up having a general damages order against them because of that. So you're not entitled to just do what you would normally do if you know someone's got a psychological disorder. As we say, just going back to what we said before, if you think they have but they keep telling you they don't, there's nothing you can do. Just some quick do's and don'ts of managing psychological illnesses in the workplace. Don't allow employees to discuss or disclose psychological illnesses without taking some action to assess the situation. As I say, it happens all the time, but it is a fraught legal issue. Don't make assumptions about what someone is capable of doing. I mean, that applies to all disability issues. You've got to assess what that particular employee is or is not capable of doing. Remember, you're an employer, not a psychiatrist. So that's just, don't make assumptions of someone's got this condition, that means they can't do it. Require medical evidence for your employee. Again, some people have a right to privacy, but if it affects the job, if it affects their safety, consult with the employee about the possibility of reasonable adjustments that could be made. This is critical because you might think there's nothing we can do. Talk to the person. There may be nothing you can do, but you have to at least get their input. It might give you ideas you hadn't thought of, and even if it doesn't, it's going to make the eventual termination a lot more pleasant if you talk to them. Suspend the employee on special leave during the process if anyone's in danger, and that comes when someone's behaving really erratically, not just around machinery. It can be erratic behaviour in the workplace. Highly erratic behaviour can be damaging to other people's psychological. I was just going to say that in workers' comp, it's pretty much the same whether it's a workplace injury or a non-workplace injury. Some people think the obligations only click in when it's a workplace injury. There's 3 key differences. One is you cannot terminate because a person is unfit for work within 6 months of the person having a workplace injury. That is an offence. So you have to wait at least 6 months if it's an employee, if it's a workplace injury. If the person then becomes fit within 2 years, they can have a right to reinstatement. There's return to work obligations, but that really applies to everyone. The main difference with workers' comp is that if it can affect your premiums and your obligation if you don't find suitable alternative duties, depending on what size of business you are. So those are the main differences. But it's not, we have to do something if someone's got a workplace injury and we don't. The differences are pretty small. It's about accommodating people in the workplace to the extent possible, because such a great proportion of people do have some kind of disability.
And reinstatement doesn't happen very often, so don't
Yeah,
worry about that.
Don't worry about that. It's not like someone on parental leave where you have to warn. So
Does the 2 years start from the date of injury or the date of termination? Date of injury.
Okay, so this is just that checklist that someone raised, and this is the last thing. So an adverse medical diagnosis is not the trump card. As we said, it's not just because I've got this, like in Jetstar, that means I just terminate without talking to the person or following procedure. So you've got to communicate and consult with the employee, give them an opportunity to respond, give them a support person. Sorry for going so over time. If anyone has any questions, or let's have a further drink and ask us a few questions, but some of them probably have to dash off. As I say, it's a big topic, and talk too much. Thank you.
Thank you very much.